Hey, what's going on, YouTube? Long time no hear or see. This is AD, aka AD Beats LV, coming back with a whole slew of more videos. First of all, I'd like to say I appreciate everybody leaving the comments and asking about my well being. I'm good, you know what I'm saying? It's just, sometimes, in life you get handed some bad cards, things happen and it just totally knocked me off my square. I'm not gonna even hold you. It just threw me all off. I just lost all motivation just because of things happening. And sometimes I just need to overcome that. Sometimes it's hard. But I'm good. I'm alive, kicking like a live chicken. Still trying to hang in there, take each day, day by day. Don't let things stress you out. That's the number one rule in my book is try to stay as stress free as you can, So, but with that being said, hopefully, I can keep up this content steadily and we can keep going up with the subscribers and the viewers, and I appreciate all you guys' time, so I know time is valuable, something you can never get back, right? So with that being said, let's get into some court videos. This content creator is Old Squishy Gardner. He has some great videos on there. I encourage you guys to go check him out. I'll put his link in the description, of course, his handle, so you can go subscribe to him, watch him. If you just want to go down the rabbit hole and watch him, this is a channel to do it, and that's the channel to do it. Mine just has a little commentary added to it. So with that being said, let's get right into it. I haven't watched this one, but it looked good, so let's see what happens.
I was in the county jail all that time till the guy tried to use me as an scapegoat, and I protected myself. Can y'all hear me?
Yep. Can you hear us?
Yep, I can.
Okay. All right. Today's the date and time set for your motion, Mr. Whitsett, to withdraw your no contest plea. I've had a chance to review your motion or submitted by your attorney, review the response. So I'm familiar with everything. I'm going to offer you the opportunity to place anything on the record you'd like, but you don't need to repeat yourself because I've read it.
Okay, thank you. Well, I think the gist of it is that this court needs to determine if the plea was voluntary, whether it was due to conditions of the jail, or whether it was a voluntary plea without any coercion. Now, there was no one from the prosecutor's office or the judge or his attorneys that coerced the plea. It was the condition of confinement. And I know the court, I think in this took pains to go through and make sure that Mr. Whitsett fully understood his rights. However, I guess you can't ask every question that would lead to an involuntary plea. So the specific question, and I'm not faulting the court, but if the court asks, are the conditions within the Washtenaw County Jail leading you to want to get out of there and rush a plea so you can move on to the MDOC? I mean, that would have been the question, but of course, you can't ask that on every case because you don't know if that's an issue. But I think the shackling was documented by one of his two attorneys, Ms. Hamoud, in her letter that I attached. So he was confined and vulnerable in the Wayne County or Washtenaw County Jail based on the conditions. And even when he's showering, he had to have the shackles 24/7, really, or any time he was outside of his cell. I know that they did that for...
Anytime you have teardrops coming from your eye, that's definitely not going to be a good look in court, for sure. Let's go.
Possibly because of an incident that happened with him, but he did allege that he was by Captain Clifton, who was one of the top people at the jail, and if that's the case, then if someone at that high level can attack him, then and anyone can, and he didn't feel safe. So with that, I will request that the court, before making a ruling, will schedule an evidentiary hearing so we put all this on the record. Court can make a fully informed decision on whether the conditions of confinement led to Mr. Whitsett taking a plea when he was actually innocent and didn't wish to plead no contest like he did.
Okay.
Let's go.
Thank you, Your Honor. So not to repeat, we do rely on the arguments in our brief, but just to highlight a few points in respect to co-counsel statements. The standard of review here, Your Honor, is under MCR 6.310C, whether there was an error in the plea proceeding. And it's our position that the defendant has failed to establish any defect in the plea taking process. Without that, Your Honor, there would be no reason to allow withdrawal of the no contest plea or have an evidentiary hearing. In the plea taking under MCR 6.302, this court very diligently applied every single step of the requirements within that plea taking process. He was represented by not one attorney at that hearing, but two. Both of them agreed that the rule had been complied with and there are no promises, threats, or any other inducements. The only evidence that the defendant presents to this court is his own affidavit and a letter from Ms. Hamoud. Regarding the letter first, the conditions, his discomfort, if you will, with the restraints in the jail, case law is very specific, that's not going to be enough. With regard to the affidavit, his sworn affidavit is in direct conflict with his sworn in-court statements. And that also, case law is very specific, is not going to be enough to allow withdrawal of the plea.
Uh-oh.
Regarding the veracity of the affidavit, we already know his comments regarding the May 5th incident, which is why he was required to wear those restraints, is untrue. We know that the record establishes in the May 5th incident, in case 23-481-FH, that was part of a global plea agreement with this case. And in that case, he entered a no contest plea to aggravated assault and dismissal of a felonious assault and unlawful possession of a weapon in jail. And that police report, which was accepted as the factual basis, as Your Honor would recall, was for him attacking another inmate with a self-made shank in the back of the neck.
Oh, jeez.
So in that regard, the case law is very specific that when it's his in-court testimony at the plea stating that there were no promises, there were no threats, there were no other inducements, having an evidentiary hearing would only subject him to perjury to directly contradict that to those statements. With regard to the June 14th incident, we have presented an offer of proof in what the testimony would show, and that also would not bear to be true. Even if there was any sort of mistreatment in the jail, which we are not admitting that there was, the case law is very specific that the defendant has to prove that that mistreatment was aimed towards forcing him to plead guilty. And there's also no evidence of that. There's also no evidence that he ever presented any of this information to the court since the May 5th incident, despite the multiple hearings, and even at the plea, and even at the sentencing. So for all those reasons and the reasons articulated in our brief, Your Honor, we'd ask that it be denied in its entirety.
This guy right here in the jail suit, and you know he's in jail, but damn, bro, back up, bro. You too close to the camera, dude. Like, yo, hey, where's the bailiff at, or you know, who's in that office? Be like, bro, back up off the camera, bro. You way too close, bro. Jeez.
First of all, the affidavit does not conflict with the sworn statements in court. because there were similar questions asked, but not a specific question about what was going on at the jail. I also was just handed a note by someone in the courtroom by the name of Sheldon Arnold, and he says he was in, I think it's I block, but F block.
Counsel, like
Mr. Arnold says
brand new information that someone's in the courtroom. So,
well, I mean, he was in the jail. He was an eyewitness, so it is an offer of proof. If we did grant an evidentiary hearing, I would have him as a witness. He said he saw Clifton assault Mr. Whitsett. So, I mean, that does lead to some additional evidence that he was legitimately fearing for his safety when you have a captain at the jail. You're supposed to be looking at inmates and their well-being, assaulting him. So I think that leads to the credibility of the affidavit and calls for an evidentiary hearing.
He's raising his hand.
well, you're correct that I don't ask every question at the time of an entry of the plea. Like I asked the same three big ones. Is anyone threatened you? Is anyone you? Has anyone promised you anything? And are you doing this of your own free will? And I know that I asked Mr. Whitsett those questions because I've looked at the video myself, but you know, I do them at every plea, and I wouldn't proceed if he didn't answer in that moment, you know, no threats, no promises, and I'm doing this of my own free will, or I'm not being coerced. So I took him at his word, and I took his plea. So now, you know, the matter is before the court because the defendant's seeking to withdraw a no contest after sentencing. The allegation is the endured coercion due to the conditions of his confinement at the Washtenaw County Jail. And that because of the conditions, he was unable to tender a plea that was understanding, voluntary, and accurate. You know, I looked at Mr. Whitsett's affidavit. I've looked again back at the video, and you know, I don't find from what I observed at the hearing.
There we go.
What I observed at all the.
I don't mean to stop it again, but somebody within authority must have came in that office because, bro, he sat up quick, straight. Like, bro, get your crotch out the screen, bro. Sit up. You're in court. If that was Judge Bryant, she would have checked him off the gate. Be like, hey, man, get your hands off where you think you're on the couch. You think you just you're in the living room chilling. You know, you're in court. Sit up. Put your hands down. You know what I'm saying? Like, dude, this dude was all up in the camera. Just had his crotch. Bro, it's crazy. All right, let's go.
Court proceedings, that the affidavit, I would say, is not entirely credible to me. And so at least some of the allegations or the statements, the sworn statements in the affidavit, don't line up with what I observed. So,
well, you want to say
you
something
know,
bad?
maybe things went on. You know, though there was an opportunity for Mr. Whitsett to say all of that before he entered his plea, too, and we would have taken action at that time. I did re-review the hearing where Mr. Whitsett was tendered. He was represented by two attorneys. One of those attorneys was appointed on the assaultive case originating at the jail. Allegedly, the defendant made a shank and attacked another inmate, which created that second case. And then there were also other rules, I believe, that were disobeyed. And I believe those are the reasons it's placed on level 1 security. I can't make a finding now that there's a basis to withdraw his plea. The plea was knowingly, understanding, accurately, and voluntarily made. It comports with MCR 6.310C. I make a finding today that there was a defect in the plea, so I am finding that there was no defect in the plea taking process that warrants the withdrawal of the no contest plea in this matter. So I'm going to deny the motion today. I don't know if there's an appeal in that for you, sir, and if my bosses in Lansing tell me to reconsider it, I will. But at this point, I'm gonna deny the motion.
Can I say something? Can I say something, Your Honor?
Here we go.
Mr. Whitsett, no, there's not an opportunity for you to offer anything at this point.
Right, but you said there was no evidence in his own video. His own video, and I told my psychologist what was going on. I didn't feel comfortable stating nothing about officer assaulting me because I was in fear that I would have been assaulted again. That's why I waited till I came to prison. I would have never pled no contest to a crime I never committed. I admit to assaulting a guy.
Oh, you're on the record, right, Mr. Whitsett?
You
know you're on the record right now, and anything you say is being recorded. And all that you're saying right now is going to be used at some point in the future, right?
Yes, I don't mind it. I never did nothing. I protected myself. And what made me plead up, I kept sitting there and getting adjourned. I was in the county almost 3 years, 4 years. And the incident happened. It was inhumane for me to go to a shower and handcuff and shackle. I'm in prison right now. And if I did something bad, you still get the shower, but you don't have handcuffs on you all the time. And it's violence in here. It's not like Washington County Jail. That was the only reason why I played that. My mental health was at risk. I was at risk. It's on video. We don't have to go off my statement. My word ain't nothing. The video shows that. The video shows it. Ask them for the video. And then let's take it. Let's postpone this and look at that video. If you see that video isn't enough to stand, I'll fall back from this, Your Honor. I never did anything in this the first case that happened. I was in the county jail all that time till the guy tried to use me as an scapegoat, and I protect him.
Now this guy, he is like literally, he does sound frightened, but this dude has 2 teardrops coming off his eye. And if you know that I know, we all know what that means, right? But you know, this day and era is like, it's just art. But come on, bro. You're begging like a mug with 2 teardrops coming from your eye. 2 tattoo eardrops, meaning that you are an unaliver. I don't know. Sorry. Let's go.
Myself. Look at the video. You see how many times he walked around me? We talking about a guy that's 6'5", 300 and some odd pounds. Your Honor, I'm 5'5", maybe 180 pounds soaking wet. He kept making threats, so I protected myself, Your Honor. If I'm wrong for that, hey, you make some good choices. I'm just saying, review the factual evidence, not my word, not nobody's word. The evidence off the camera. The body-worn camera by Sergeant Burleson on Justice. It's on that video camera. If I'm lying, we never have to go through this again. I'm not asking to make a decision right now. Postpone it until you see that video. If I'm wrong, hey, Mr. Whitsett, you lied.
So if the Court of Appeals tells me to do that, I assure you I will do it.
But you're going to deny me, though.
Okay. Yep. Thank you.
Thank you, Judge.
Numbers 44 and 45, People versus Joseph Thompson, 24-262 FH 22-1.
He is going off and he's muted. He is like going off. Nobody's caring or paying attention.
Good afternoon, Your Honor. Jay Kilwald. Your Honor, I'm on Joseph Thompson's case, 24-262.
Good afternoon, Your Honor. Alexander, on behalf of the people, seeking permission to practice pursuant to Michigan Code Rule 8.10.
He's still talking like somebody's listening.
Attorney, Jonathan.
That's funny.
Joseph, would you state your name for the record?
Joseph Thompson. How are you doing?
Right. Judge Torshell Feaster on behalf of Mr. Thompson for a probation violation of the 2211 FH.
All right. So, Linda, the world has all reasserted its correctness and rightness that you are here practicing under Emmett. So I'm happy to grant that motion.
To get this guy.
Mr. Kilowald, got to tell you, in your case, we don't have fingerprints. Just letting you know that because it's pre-trial, and then in the VOP, we're.
Like, who is he talking to? Like, think he's still talking to the judge? Like, is he talking to somebody in there with him?
Just proceeding with that. So,
Judge, I would ask you to hold off on the VOP. Obviously, that's my case, and that's your decision. But as far as the pretrial, I'd like to adjourn this out maybe 2 or 3 weeks. I just had a chance to speak with my client regarding the preliminary exam we held. And I think there's some substantial points I'd like to file a motion to
That's
quash.
crazy.
I'd also like to discuss with Mr. Emmons, a situation I believe is happening with the victim. But all that being said, I'm wondering if we could adjourn this 3 weeks.
Did you see that?
I assume you would
He
make the
like
same
put up a
request on your
cross or
case.
something
Correct,
like that.
Judge.
And the other guy.
Situation I believe is happening with the victim. But all that being said,
Watch
I'm
the
wondering if we
guy,
could adjourn this 3
Curtis
weeks.
Smith.
Sir,
wait a
I
minute.
assume you
I
would
didn't
make the
go
same
for it.
request on
I'm
your
sorry.
case.
Let's go back a little more.
In your case, we don't have fingerprints. Just letting you know that, because it's pre-trial, and then in the
Now watch
VOP,
the
we're
Curtis
just
Smith
proceeding
guy.
with that. So,
Judge, I would ask you to hold off on the VOP. Obviously, that's my case and that's your decision. But as far as the pretrial, I'd like to adjourn this out
He
maybe
puts up
2
like a
3
cross,
weeks.
and then the other guy,
I just had
Robert.
a chance to speak with my client regarding the preliminary exam we held. And I think there's some
Look at it.
substantial points I'd like to file a motion to quash. I'd also like to discuss with Mr. Emmons, a situation I believe is happening with the victim. But all that being said, I'm wondering if we could adjourn this 3 weeks.
sir, I assume you would make the same request on your
Wow.
case.
Correct,
That's
Judge.
crazy.
Whatever happens on my case is gonna be, dependent on what happens on Mr. Killen.
And he's still there.
To be made.
So how about May 22nd? Zenda, what about May? You okay with that?
That works for the people, guys.
That's fine.
And they
Thanks,
don't
Judge.
see him doing
Okay.
all this.
Joseph,
That's
I'll come down
weird.
and see you, okay?
Yes, sir. Thank you. God bless y'all.
Take care, Joseph.
They don't see this guy doing all this. Who's paying attention? Nobody, obviously. Oh, now somebody finally comes and pulls his coattail and gets him after he did all that.
37 and 38, People versus Curtis Smith Jr.,
Wow.
24-254 FH,
Oh, he's
24-254 FH.
Oh, snap. Dude is
Hey, Judge.
on one. Wow, bro, that is crazy. Yo, that was crazy, y'all. Like I said, I didn't watch that one. It looked interesting. I mean, that one was okay. That's kind of weird how, he's just keep rambling on after his case is over and nobody is even paying attention to what he's doing. Like, that's a little weird or whatever. But hey, I appreciate everybody for your time. If you can like, subscribe, comment, I appreciate everybody who was checking up on me. My bad, I was just going through some things and I was just knocked off my square pretty much, and I was just like in a shell. But I'm back. Time to get busy. I got some other stuff going on too as well. I got another channel that I'm gonna start up, and it's DIY guy 702, and I'm about to take up on probably trying to start to grow. I don't know if anybody's heard of the Grow Box Abby. I picked one of those up, and I think I'm gonna go ahead and shoot my shot and try to grow my own plants. I've always wanted to try to do it, and I think I'm gonna just document everything on my DIY 702 channel. Actually, it's DIY guy 702. But once I get that going, I just received the Abbey. I'm waiting for my plants to come, or my plant, so I can go ahead and plant it. And I'm gonna be making videos about that on the other channel, plus some other stuff as well. I'm kind of like a handyman as well. I do like all kinds of different projects around the house, remodeling, just all kinds of different things. So, if I could have it my way, and if it was my dream, I would just be doing this, not going out of town every week to work. I would be doing content and growing some trees and trying to possibly be able to be a distributor for the dispensaries here. Who knows? But yeah, if my world was perfect, I would do this all day, interact with you guys and all that. But that's not possible at this point. So got to do what you got to do. I appreciate everybody. Have a great week. And stay safe out there. This is AD, aka AD Beats LV, and I'll check y'all in the next one. Peace out.